Good morning, everyone, and welcome. We're pleased to have you with us today. We have 4 cases on the morning docket, and we will hear them in the order in which they appear on the docket. Let me remind counsel that each side has a total of 15 minutes for your argument, and that applies whether there's one attorney or multiple attorneys arguing. If there are more than one, you'll have to share the 15 minutes. And the appellants, not the appellees, but the appellants have the right to reserve up to 5 minutes for rebuttal. So when you come to the podium, after you've introduced yourself, please let us know how many minutes you would like to reserve, and the clock will be programmed accordingly. The Court of Appeals of Tennessee is one court. There are 12 judges. We serve across the state, even though we are elected from one of 3 grand divisions. Today we are honored to have with us Judge Karma Dennis McGee from the western section. We're very thankful that she's here with us, and while she sits with us today, Judge Bennett and I have gone to Jackson this year, and we've both gone to Knoxville this year, but we always look forward to our trips there and her trip here. Are there any announcements or introductions? Hearing none, please call the first case.
Stephen Brecker versus Virginia Story et al.
Good morning, Mr. Blackburn.
Good morning, Your Honor. Gary Blackburn of the Nashville Bar, and I would like to reserve 3 minutes, please.
3 minutes, yes, sir.
Right. May it please the court, this is an appeal from Williamson County in a legal malpractice claim. The case was handled by Judge Parks, who is from Columbia. I only point that out because there's some practical issues, but I don't think they have anything to do with what we're discussing this morning. Because this was a legal malpractice claim, it was essential, as the court knows, that this be demonstrated by expert proof. Our expert was former Chancellor Darrell from Knoxville. I was asked to be involved in this case by counsel from Utah, and I pointed out that we had to have someone to testify or there was no case to proceed. That was an absolute requirement. So we found Chancellor Fansler, who gave us an opinion. Now, ordinarily, as the court knows, an appeal from a summary judgment would be heard de novo without presumptions. However, the issue in this case is the exclusion of Chancellor Fansler's deposition, or declaration, excuse me. That means that this is technically an abuse of discretion issue. I've always thought that term was a bit harsh. I think we're really talking about failure of discretion rather than abuse. This trial judge is a very fine judge.
I fully agree with your comment.
Thank you. Now, I characterized what happened that resulted in the late filing as a perfect storm. I think perhaps Murphy's Law would be more accurate. Things were being provided from Utah counsel at the last minute. These were things that she felt strongly about, and I was pleased to try to do that, to facilitate that discussion. However, the volume of documents sent were too great for our computer system. As Your Honor knows, I began practicing law with a rotary dial phone, so I'm not an expert in this area. However, the other thing that happened was that this case was changed. The hearing date for the motion for summary judgment was changed. Nothing unusual about that or inappropriate. But what it meant was that if you went back 5 days, it fell on Good Friday. Good Friday is by statute, is a legal holiday. So the Williamson County Clerk's office was closed. The judge's office was in Columbia, but it was a holiday. As a result of all this, there is no dispute of fact as to whether these papers were filed late. They were filed on Monday. I would respectfully submit that this is not a trapdoor situation. If we had failed to file the notice of appeal within 30 days, this court would lack jurisdiction. There wouldn't be anything any of us here could do about that. In this instance, though, this was a matter of discretion. So if you count back from that Friday, you wind up on the prior Friday, which was a holiday. So you go to Thursday. That means that the deadline was 8 days before the oral argument. It is what it is. We don't quarrel with the judge's arithmetic or that conclusion. However, denial of our right to present Chancellor Fansler's declaration is not mandatory, as it is not jurisdictional. It's within the court's discretion, hence our appeal here based on abuse of that discretion. Now, there's nothing, only thing that we're asking is that the court find that it would have been appropriate for Judge Parks to have considered that declaration, particularly since when we had the oral argument, he commented on it, read it, and observed that that declaration, if it were admitted, would create a question of fact. This was the defendant's motion for summary judgment. He made that comment. The defendant received Chancellor Fansler's opinion before COVID, fall of 2019, and at a time when Mr. Buck Cole was representing the defendant. Subsequent to that time, we had the delays, which you're all familiar with, in 2020. Then at this point, there was no countervailing affidavit or declaration from the defendant. So time went on. Then Ms. Blauvelt replaced Mr. Cole, who had moved to a different firm. We scheduled the deposition of the defendant, Ms. Story, and during that deposition, she acknowledged that she had read the declaration of Chancellor Fansler. It was made an exhibit to the deposition, and we discussed it. We paused during the deposition so that she could read it again if necessary. She subsequently then submitted her own declaration as an expert on her own behalf. Not surprisingly, she thought she had not committed malpractice. So we then moved forward. They do not have any other expert. We then get to the hearing, and it really couldn't be seriously disputed what the judge said about this significance of Fansler's declaration. So the defendant asked for the opportunity to hire their own separate expert. That was granted. They also asked that we submit Fansler's testimony in a more formal format under Rule 26. We did that. That had not been raised before. They had his declaration and they had his obvious qualifications. In the meantime, they went to find an expert of their own, and they found Mr. John Hollins, Jr., who's an old friend of Ms. Story and me, and he gave a declaration obtained by them. The matter was under advisement. We were attempting to schedule the depositions of the two experts. We were going to pick a trial date and then move back from that in terms of the scheduling order when the order came down and excluded that testimony. I would respectfully submit that it's been the long-standing custom and policy of our courts to try cases based upon their merits and not upon technicalities. There is no question about whether the filing on Monday rather than the previous Thursday technically violated the rule. However, the amendment, the rules of civil procedure were adopted actually when I was in law school. In 1999, I believe it was, is when the amendment occurred. The amendment was fair, just. The 5 days, I don't think maybe was thought through. We have a long-standing custom in the 20th district here, Davidson County, of filing responses to summary judgments on the Monday even though that doesn't technically comply with the rules. They don't have that rule in Murray County. It didn't come up whether they have that rule in Williamson County, but at any rate, the filing gave them things that they already have. After the deposition, for example, of Ms. Story, we submitted the testimony to Chancellor Fansler, and he stated, and we provided this to the defendant, that nothing in the deposition changed his mind, and so the opinion that he gave in the fall of 2019 was essentially unchanged except in the format in which it was delivered. Well, they did, in fact, obtain a written opinion from Mr. Hollins, which they submitted. Recall, please, that this is a defendant's motion for summary judgment. So the question was whether it be granted or denied. The significance of this large group of documents sent from Utah really never arose. We've never discussed that. It is fair to say that the defendant had less of an opportunity to review those, of course, than they did Fansler's deposition, which they had had for years. When they submitted the summary judgment motion, then they're really pitting the expert opinion of Chancellor Fansler against that of the defendant herself. This is before Mr. Hollins. We never did get to the point of deposing the two experts. Chancellor Fansler is in Knoxville. Of course, their expert was local, but we were trying to do that at the time the opinion was rendered. The idea of the purpose, at least the expression of the purpose behind the change in the rule, was so that the court and the defense attorney or the opposing counsel would have a chance to be prepared. There is no question whatever that they had the chance to be prepared and were prepared and did discuss Fansler's deposition or declaration at the time of the argument of the summary
judgment.
So your
position is that the declaration added little, if anything, to what the Chancellor had already opined and what you and your Utah counsel had already provided to defendants.
Yes, Your Honor. The things that were provided from Utah counsel had to do with things that weren't really discussed in the declaration. It had to do with whether she had properly prepared Mr. Brecker for his cross-examination. There are things that are of interest, generally relevant, but at the center of this was the expert opinion, as it is in any professional liability case.
Judge Parks seemed to place some emphasis on two things. One, that the motion for summary judgment and supporting documents was filed some 5 months before the hearing, and that the declaration in response to the motion was not filed before the 5 or 8 day threshold. What justification is excusable neglect is there for that?
Well, Your Honor, when the rule gives you a deadline, which I can't stand here and say we strictly adhered to, that is traditionally the deadline. You don't file your responses to summary judgment months before the hearing date. This was complicated by the fact that we had out-of-state counsel and trying to communicate between. Now, I don't mean any disrespect to her. She's an outstanding lawyer. But she was looking at this in terms of her own experience, as was I. And but I think the key point is that there is no demonstration of any detriment or harm or prejudice to the defendant in the timing of any of these things. This date that was technically correct, that is the previous Thursday, is 8 days before the date for the hearing. And had these documents been received sooner in a manner in which they could be opened and printed, it would have been filed on Thursday, but that didn't happen. So we're not trying to defend that. We're not trying to say that was a neglect. The problem is is that having stated from the bench that Fansler's declaration created a question of fact, he then excluded it,
Right.
having allowed a countervailing affidavit or declaration to be produced.
All right, thank you, Mr. Blackburn. We'll hear from you on rebuttal. Good morning.
Good morning, Your Honors. May it please the Court. My name is Gage Smythe. I represent defendants Virginia Story and the law firm of Story, Abernathy, and Campbell. The only issue on appeal here is whether the trial court abused its discretion by striking the late filed documents of plaintiff and refusing to consider them when ruling on defendant's motion for summary judgment. We ask that the judgment of the trial court be affirmed.
What prejudice did your client suffer from the late filing?
The prejudice, even if it was relevant, there is prejudice here. Plaintiffs first focus their undue prejudice argument on the fact that this report was provided to defendants sometime before this motion for summary judgment hearing. That report is actually a letter dated November 7th, 2019. The main documented issue here is the declaration of Chancellor Fansler, dated April 6, 2023, the day that these documents were due. They're completely different documents. They're not the same. One's a letter, the other's a declaration. There might be some overlap in terms of the opinions, but it's not for defendants to say what or what not your documents are going to say. We can't assume, based on what's been provided previously, that this new declaration was going to be substantively the same as the report. The next argument plaintiff proposes...
So, excuse me, so you're saying that this declaration was dated on April the 6th, which was essentially the day that they would have been due to be filed?
Yes, Your Honor.
And that document, or that declaration prior to that time, did not exist then?
We had not received it until it was filed with the court on April 10th.
Thank you.
The next argument plaintiff makes is that because defendants were able to reference and read from the document at the hearing, that means no prejudice resulted. I don't think that can or should be the standard. I think if you handed someone a document the day of the hearing, they could look at it, read it before, and reference and read it during arguments. That's not the standard. And that can't be what we find, or that can't support an argument that there was a lack of prejudice. These documents were supposed to be provided on April 6th, giving defendants time to prepare for oral argument, to prepare a reply if necessary. They were not provided at that time. That deprived defendants of 4 days in which they could have been reviewing the 500 pages of documents that plaintiff filed. There were also 68 additional facts submitted by plaintiff. Depriving defendants of those 4 days is prejudicial. It takes away time that you can prepare, takes away time from the court, which, as plaintiff has referenced, is part of the purpose of Rule 56, is to provide the court time to review the documents that you file. In this case, Judge Parks was not just having to review these 500 pages of documents and prepare for that hearing within 4 days. He was also presiding over 3 other counties of cases. So the late filing also takes away from the purpose of Rule 56 by depriving the trial court of the time they need to prepare for these hearings. I think Rule 56 is clear, and Tennessee law is clear, that the requirements of Rule 56 are mandatory. This court in Garner v. Coffee County specifically said they're mandatory, and that while a trial court may waive those requirements, it's not a requirement for them to do so. It's a discretionary decision. And that means that they have multiple alternatives to choose from, and we have decided that the trial court is best situated to make that discretionary decision. There really can only be overturn of the trial court's ruling if plaintiff can show that there was some abuse of discretion. And what you haven't heard today is any reference to the bases for an abuse of discretion finding, which would be applying an incorrect legal standard, reaching an illogical or unreasonable decision, or basing its decision on a clearly erroneous assessment of the evidence. These are the only bases for finding an abuse of discretion. Plaintiff hasn't addressed them. They're clearly not an issue here. And plaintiff instead focused his argument on that undue prejudice claim, which this court has already rejected. In that Garner case, plaintiffs argued the same thing. No undue prejudice resulted, therefore, their argument should succeed. This court rejected that argument, said that undue prejudice is not relevant, it's not the issue. Abuse of discretion is based on those 3 factors alone. I just wanted to note briefly that, this case was brought alleging, among other things, a lack of timeliness as to filings. The irony of that aside, I think there was no, hidden trap here. These rules are well established. I think the amendment to Rule 56 was passed in 1999 when I was in the 3rd grade. They are long-standing rules. Every attorney knows them. Every attorney knows the possibility that if they file their documents late when responding to a motion for summary judgment, there is a possibility those documents will be stricken and not considered. That's what happened in this case. That was a discretionary decision of the trial court. Judge Parks authored a very thorough opinion in this case where he went painstakingly through each date, each rule, and essentially said, I am exercising my discretion in this case to strike those documents and refuse to consider them. This was not a time crunch situation. As has been pointed out, this was a 5-month period between the time defendant's motion for summary judgment was filed. It was initially set for a hearing in January. It was continued because of a request from plaintiff, which we were happy to agree to, and then reset by the court one additional time. So this was not a quick turnaround time. There were 5 months in which to get these documents prepared and get them submitted on time. The April 6th date did fall on April 6th because of that Good Friday holiday. But as we all know, ignorance of the law is no excuse. And the fact that it fell on Good Friday does not excuse the fact that they were filed mostly on April 10th, but also some of the filings were on April 11th. So they weren't fully filed even until April 11th, which was just 3 days before the hearing.
Judge Parks seemed to be concerned with one additional thing, one I mentioned earlier to Mr. Blackburn, but he observed that the certificate of service represented that the documents had been mailed and or filed with the clerk on a certain day, but he surmised that could not possibly have happened. What's the factual basis for that, and what's the significance of that?
I believe the documents were filed on April 10th with some backdating, or possibly on the 11th with some backdating to the 10th or the 7th. Regardless, plaintiff's earliest attempt to file these documents was on April 7th, which was already past the deadline. Judge Parks did point out that those dates were inconsistent, but regardless of that, the filings were not made until April 10th and 11th.
So either date would have been late. Is that your position?
Yes, Your Honor.
Okay, thank you.
If there are no other questions from the court, I ask that the judgment of the trial court be affirmed.
Hearing none, thank you, Mr. Smythe.
Thank you, Your Honors.
Mr. Blackburn, your rebuttal.
Please, the court, the documents were signed by me the prior week. When she had difficulty filing them, she didn't bring it back to me. I didn't even notice that, and that's why the documents are different. They were signed on the day I intended them to be filed. The argument that the declaration is not the same thing is an argument of form over substance. The opinions expressed, and the court can look at the letter, can look at the subsequent letter to Ms. Blauvelt, which said that this was not going to be changed. His opinion was unchanged by the testimony of the defendant in the deposition. That's the deposition in which she commented on the expressions of opinions of Chancellor Fansler herself. The court granted their request that we have, in addition to the letter, the subsequent explanation, the declaration of the defendant, and then the declaration itself, which simply put into a declaration format the opinions already expressed, that we submit a Rule 26 response. Now, whether it may be called punctilious or not, we did it. So that was after the date of the argument. We're still looking at that. Then they got their own expert, who's a very qualified lawyer, and responded so as to respond to Fansler's declaration. His opinion is unchanged from 2019. So I'm not sure what that argument is about. The court, and I quoted this at page 4 of our brief, one of his comments was, it doesn't create a disputed fact, a material disputed fact, question mark. Doesn't he say in his declaration that failure to meet the deadline was tantamount to legal malpractice, or words to that effect? And he said, if he says that, does that not in and of itself create a disputed material fact? The response was, yes, Your Honor. If it says that, it would create a disputed fact. So we all knew what this was about, and I'm not concerned, I should say the appellant is not concerned with these other documents, not considering them. That's a fair comment. There was a large volume of them, and they were somewhat tardily filed. There's no dispute about that.
You're referring to the other documents, such as the statement of disputed facts? Is that what you're referring to?
Well, there were, he said 500 pages. I don't know how many there were, but I got a lot of pages from Utah. And none of those are anything we're asking the court today or in the trial court to consider. Just the declaration. The concept is that we should decide our cases based upon the facts and the law and not on simple procedural irregularities. We have a procedural irregularity. Nothing I can say here would dispute that. However, the court, on the day of the argument, had the discussion of that declaration and expressed an opinion. As a result of that, we would submit it was, I want to avoid the word abuse, it was unfair and unjust not to consider it.
All right. Thank you, Mr. Blackburn and Mr. Smythe, for your arguments. We'll take this case under advisement. Call the next case, please.